Welcome to the Minerva seminar and Minerva community. Just spoke, Rottem and I, how it is actually for resilience in these very difficult times, how wonderful it is to have this gathering every 2 weeks. And we're very happy to host today Dr. Rottem Rosenberg-Rubins, who was a postdoc at the Minerva Center and now is a lecturer at the law faculty or law school of the Ramat Gan Business and Center for Law and Business. And Rottem was here at Minerva under the supervision of Professor Gad Barzilai, and she will present a paper that was co-authored with Gadi. As we all know, Gadi passed away about 10 months ago, and in the prime of his career. And we said that it might be a good opportunity to say a few words in memory of Gadi, and our dean, Professor Jarski, will have the floor to say.
Thank you. Thank you, Professor Salzberger, and thank you for Michal for facilitating. And thank you, Rottem, for joining us here again. So indeed, as Eli said, a bit less than 10 months ago, during Passover of last year, we lost our dear friend and leader, Gad Barzilai. Much has happened since, and it's been a few times that we noted in our faculty how much we miss him and how much we feel orphaned without him. And Gadi's leadership has showed us example how to get through times of peril, times of difficulty, which we had so many of in the last few months. Given our battle for democracy, and thereafter our battle for survival. We think of Gadi often in his ability to bring people together, bring them closer. And also we think of his generosity. And Rottem, I guess, could firsthand talk about how together they worked on this publication, perhaps Gadi's last publication. And his generosity is still with us. His family made contributions. And just a few hours ago, one of our faculty members told me how they distributed substantial amounts of money, tens of thousands of shekels, to people in need, soldiers and refugees, actually, and other people that were harmed by the recent events. I also want to mention another form of generosity from Gadi. We just had a seminar here, and I think many of us felt his absence. Gadi was extremely generous in seminars, in giving comments, in giving his knowledge, sharing it with proteges, which Rottem was one of which. And he did leave us a big hole in our hearts and in our knowledge and our faculty. And thank you, Rottem, for celebrating his contribution and scholarship with us today.
Thank you. I'm very happy to be here, but I'm also a little sad because I wasn't supposed to be presenting this article alone. I thought, I always thought that when it came time to present the article after it was published, that Gadi and I would present it together. Gadi was my advisor here at the postdoc, at my postdoc in the Minerva Center. And I'm sure that, as you said, no one here will have any trouble believing that he was incredibly generous with his time and incredibly supportive, always willing to offer advice and assistance, not just to me, but to numerous other young scholars whom he helped in the first steps of our academic careers. And it was really amazing to see at his funeral. I met several people whom I knew from entirely different contexts. I had no idea that they had anything to do with Gadi, and then suddenly I met them at the funeral, and it turns out that they were students as well. So really, I think the extent of his help and his influence, his academic influence, really was huge, and it was very moving at the funeral to see that. And apart from all that, Gadi was also an enthusiastic advocate for democracy, who dedicated a lot of his work to the subject. And the article that I'm presenting today that we co-authored engages with this issue by looking into the role of international law, and particularly international human rights law, in preserving democracy amid emergencies, in limiting state action, the actions of nation states, of individual states, during times of crisis. So the article was written in the midst of the COVID-19 pandemic, and I think it's very clear from the article that this had much influence on the article. It was heavily influenced by the concern that the state of emergency during COVID would lead to an erosion of democratic principles, not just in Israel or in any particular country, but on a global level, a widespread and worldwide phenomenon of democratic erosion. Because during the outbreak of the pandemic, we witnessed the widespread use of emergency powers worldwide, not just in Israel, in many countries, which constrained, at least to some extent, civil rights and limited parliamentary and judicial discretion. But the article is, of course, relevant not only to COVID, but also to other types of emergencies, not necessarily pandemics, because we all know, and of course the Minerva Center is very much engaged in this, that in various situations of crisis, democratic states often introduce special executive powers, including powers of arrest and detention, creating military tribunals, enacting criminal laws that are applied retroactively, limiting the right to freedom of expression and association and assembly, and the suspension of various procedural rights, things that we tend to see during emergencies in countries that are considered completely democratic and define themselves as democracies. And this is sort of the problem that started the article. The idea that there is a need for clear legal norms for governing emergencies while preserving the underlying principles, the most basic principles of democracy, not just in each individual state, but on a global level, where the threat to democracy is not limited to the regime of one country or another, but becomes a global hazard. And this is partly because emergency politics does have transnational features. The responses of individual states, and this was quite, I think, apparent during COVID, the responses of individual states affect one another. And domestic publics are likely to evaluate their government comparatively by looking at the actions and experiences in other countries. So in the context of the pandemic, we saw this, this was evident regarding the length and severity of lockdowns, vaccination programs, and other executive action taken by various countries. And of course, these inclinations also exist in other global emergencies, such as terrorism, warfare, economic meltdown, or climate catastrophes. This is the problem that we set out to explore in the article, the growing need for global norms for governing emergencies. And this led us to the question of whether such norms may be found in the field of international law, a question that to date we thought has received insufficient attention in the literature. And so the article attempts to take a step in the direction of providing a sort of methodical, systematic analysis of the potential role of international law in the protection of democratic principles. And we examine this role, or this potential role of international law, on two main levels. First, we discuss three basic models for coping with emergencies in constitutional democracies, and we examine whether international law plays any parts in these models, or whether these theoretical models themselves assume that state action should be governed through domestic law exclusively. And the second level is the level of positive law. We study international law's a general level of support for democracy, as well as the norms of international human rights law that could potentially restrict national state power under emergency rule. Before I begin, I'll just say that for the purpose of the article, we adopt a relatively narrow definition of democracy, which entails three main components: free elections, a small set of core rights that are related to political contestations, such as rights to free speech, association, and voting, and the rule of law. And so we set out to answer the question whether even applying this relatively minimalist definition of democracy, we can say that international law truly supports it and provides a positive support for this type of rule of government. So can we change slide 3? Great, thanks. So we start the article in part 1 by discussing three main models for coping with emergencies in constitutional democracies, which are outlined in the literature. And here we use the conceptualization that Gadi Barzilai offered, and that I'm sure that many of you have already heard, so I will be brief. Broadly speaking, Gadi has suggested that we can recognize three main models for coping with emergencies in constitutional democracies, which he has termed the suspension model, the expansion model, and the legal adaptation model. And I'll say a few words about each one of them. The suspension model, which is perhaps best identified with the works of political theorist Carl Schmitt, refers generally to a shift from a liberal democracy to an authoritarian model of government during states of emergency. This shift occurs via suspension of the regular laws of the state, which normally guarantee civil rights and separation of powers. The suspension model may entail a sharp and rapid shift from a liberal democracy to an authoritarian form of governance, or it may also entail a more gradual shift during which only certain civil rights are suspended. In both versions, however, the model is based on the distinction between norm and exception, and the main fear, of course, is that this distinction will eventually collapse as the emergency becomes prolonged, and that emergency measures that are originally intended as temporary suspensions of the rule of law would become permanent arrangements eventually. Thus, scholars like Clinton Rossiter, for example, have suggested trying to stipulate in advance the procedural and substantive limitations on these exceptional emergency powers in what Rossiter refers to as constitutional dictatorship. Constitutional dictatorship. The expansion model refers generally to the tendency to expand the role and the authority of experts or certain state officials in times of emergency. It allows for militarization and or medicalization of society, typically with military or medical experts dominating government in times of a national security crisis or a health crisis, respectively. This model is perhaps best identified with Harold Lasswell's Garrison State, an institutionalized military state designed to cope with threats to national security, which may become permanent and long-standing. In such states, Garrison argues specialists on violence will become the most powerful group in society. Authority becomes dictatorial and centralized, with the elite recruited based on military and technical ability in times of crisis. And the third model, termed the legal adaptation model, aspires to prevent the shift from liberal democracy to strict emergency rule by embedding emergency legislation into the normal civilian legal order of the state. It attempts to anticipate the onset of an emergency by providing temporarily limited legal powers designed to address the urgent event and allow for the reconstruction after this urgent event has been resolved. This model is becoming increasingly common, with some 90% of constitutions in force today, including some sort of provisions on emergency powers. The model provides a strong contrast to the suspension model, as it normalizes the state of emergency through mundane and routine practices, rather than viewing emergencies as ground for a comprehensive yet temporary suspension of the rule of law. It also attempts to overcome the dangers of the expansion model by limiting ex ante the role of emergency legislation or of experts such as military or medical experts. However, this requires embedding the concept of the emergency into the legal structure of the state, thus allowing for long-lasting restrictions on human and civil rights. The first main argument of our paper concerns a main limitation which we identify with regard to all three models. We argue that all three models are limited in their capacity to cope with global emergencies as opposed to national emergencies, because they are characterized by what Wimmer and Schiller, as well as other scholars, have termed methodological nationalism. Methodological nationalism is a national outlook on society, politics, law, and history, which assumes that the nation state is the natural social and political form of the modern world. Wimmer and Schiller argue that such a national perspective governs the political and sociological imagination, despite the fact that transnationalism has long become a constant of modern life. And the traditional theories concerning the threat to democracy in time of emergency, which sort of informed the three models, suffer, in our opinion, from such a methodological nationalism that limits them from thinking about the deterioration of democracy on a global scale. These theories were conceived in a far less globalized world than the one we know today, with international law less developed. Thus, they do not consider the potential role of international law in governing emergencies. They view the nation state as the natural unit of analysis for examining the challenges that emergencies pose to democracy. And they pay little attention to the possible implications of a process of de-democratization occurring on a global scale. This is certainly true for the suspension model, which places much emphasis on the sovereignty of the nation state and the powers of its executive. It is also true for the legal adaptation model, which relies on the state constitution to govern emergencies and strives to fortify national sovereignties in times of emergency by creating special executive powers in advance. The expansion model, particularly in the form of the garrison state, involves a more global way of thinking, since militarization typically holds direct implications towards a country's foreign policy and international relations. Yet, even Harold Lasswell, whose works were influenced by global crises and who did not limit his predictions to any specific country, but rather offered a forecast for a future world order, still focused on the implications of militarization towards the internal social order of the nation state. So in this sense, we argue that the models are somewhat dated and that a different cosmopolitan perspective is needed for the age of globalization and global governance. Hence, we pose the question whether these models are correct in largely dismissing international law, or whether international law, particularly international human rights law, may provide global norms, assisting countries in adapting to states of emergency. And this question is explored at length in part 2 of the article, which focuses on three main problems that we view as limiting international human rights law from effectively protecting democracy amid emergencies. So we raise the question whether international law can be considered at all pro-democratic, whether it explicitly endorses democracy as a form of government. The second problem we consider is that even assuming that international law does have a pro-democratic agenda, this agenda does not necessarily translate into democratic or constitutional features of international law itself. And the third problem, we sort of grapple with the question of whether international human rights law provides effective norms for preserving democracy amid emergencies. So are these norms that are enforceable? Do they pose clear and concrete limitations on state power? And here too, the answer proves complex due to various constraints imposed through national sovereignty, the flexibility of international human rights law norms, and the wide prerogative that states enjoy when it comes to derogating from human rights during emergencies. The first problem to consider when discussing the role of international law in preserving democracy is that even going by a relatively minimalist definition of democracy, as we offered, it is unclear that international law explicitly endorses this form of government for two main reasons. First, many of the players in the field of international law are not democratic. It is true that since World War II, much of what we have come to think of as international law has mainly been the product of liberal democracies. However, the number of democracies in the world has been in decline since 2006, with less than half the world's population currently living in nations that are full or even flawed, so to speak, democracies. Today's dictatorships utilize international law, and they're largely integrated into the global capitalist economy. Thus, they rely heavily on international trade, labor, and investment flows. In fact, Ginsburg suggests that we are currently witnessing the rise of authoritarian international law, defined as international legal behavior that is designed to undermine the spread of liberal democracy and extend the reach of authoritarian rule. This means that international law itself may be transformed by authoritarians. And second, international law gives much weight to the right of states to self-determination, and it generally does not intervene in their chosen form of government. Moreover, the formal support for democracy provided by positive law is significantly limited, even in international human rights law. On one hand, the central international human rights treaties do mention democracy. For example, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the American Convention on Human Rights, and the European Convention on Human Rights, all allow states to restrict rights when necessary in a democratic society. The European Convention seems to take the most explicit pro-democratic stance, stating it in its introduction that fundamental freedoms, which are the foundation of justice and peace in the world, are best maintained by an effective political democracy. However, on the other hand, the issue of democratic or non-democratic regimes is not part of the law as positively expressed in the treaties. And the classical view of the international legal system is one of ideological pluralism. According to this view, international law in its essence is agnostic regarding regime type, and its central purpose is not to facilitate the spread of any particular form of government, but instead to facilitate the interactions of governments of very different types. So to conclude this point, it seems impossible to think about international law as a whole as inherently pro-democratic. Some things that democracies do with international law, such as human rights agreements, democracy charters of regional organizations, and election monitoring, are of course designed to protect and extend the sphere of democratic governance. But nonetheless, much international legal behavior, does not have this specific character and even aims explicitly to promote authoritarian principles. So this is the first problem. The second problem we discuss is whether international law itself behaves democratically. Even assuming that international law does support democracy as a form of government, does it lead by example? Do international organizations, for instance, adopt democratic and constitutional principles? If so, do these principles guide the organizations in their own emergency policies? There are two main disciplines that underscore the democratic and constitutional qualities of international law. The first is global constitutionalism, the second, global administrative law. So the first discipline, the emerging discipline of global constitutionalism, challenges the view that international law is pluralistic or agnostic regarding regime type. Global constitutionalism underscores the constitutional qualities of international law by rereading the founding treaties of some international organizations as the constitution of those organizations. On the descriptive level, it argues that globalization and international legal developments continue to inch gradually toward a global constitutional order. On the normative level, some scholars advocate what they call compensatory constitutionalism, namely the development of global constitutional law as a strategy to compensate for the deconstitutionalization of domestic governments in different countries. The second doctrine, global administrative law, is a scholarly agenda developed by Kinsbury and fellow scholars, and it refers to structures, procedures, and normative standards for regulatory decision-making that are applicable to various intergovernmental regulatory bodies. This discipline contends that there is and ought to be a global administrative law, which governs the conduct of such international entities to promote accountability, fairness, protection of individual rights, and to some extent, at least, some sense of democratic decision-making. So global constitutionalism and global administrative law do provide some sort of potential model for entrenching democratic principles via international law. However, many have criticized both the descriptive and normative assumptions of these doctrines, and global constitutionalism in particular is considered a somewhat utopian theory. The potential of global constitutionalism to compensate for the decline in constitutional democratic principles on the national level seems limited, because to realize this potential, the production of primary international law and of the secondary lawmaking of international institutions must itself be democratized on two tracks. On the status track, citizens should continue to be mediated by their nation states that act for them in international relations. But we will also need a second individualist track through which citizens may be able to bypass their intermediaries, the nation states, and take direct democratic action on the superstate level to combat attacks on the state's constitutional order. Such an individualist track has so far been quite limited, so it's unclear what potential this model of compensatory constitutionalism could really be. Another challenge to both these theories is the apparent willingness of international organizations themselves to deviate from constitutional and administrative principles when conducting emergency politics. There is evidence suggesting that much like individual states, new forms of post-national emergency governance likewise exercise substantial discretionary authority and stray from basic democratic principles. During the last 2 decades, international organizations have played politically powerful and legally questionable roles in a diverse set of crises in world politics. For example, in its reaction to the 9/11 terrorist attacks, the UN Security Council vastly extended its jurisdiction by empowering itself to act as a global legislator and suspending due process rights for individuals. Acting under Chapter 7 of the UN Charter, the Council also imposed on all states a number of legal obligations to combat terrorism, which must be translated into domestic legislation. So the Council really widened the reach of its emergency powers by leaving the terrain of executive regulation and beginning to legislate for the international community. There are, of course, other examples. For instance, since the outbreak of the euro crisis in 2010, the European Central Bank received extra legal empowerment to act as a lender of last resort to sovereigns in the Eurozone and to impose austerity measures on recipient states. So if international organizations offer any kind of model for governing in times of emergency, it seems that this model reproduces at least some of the failings of domestic emergency politics. It similarly justifies deviations from proper procedure and violations of some rights as necessary responses to exceptional and urgent threats, resulting in the expansion of executive power and the erosion of constitutional principles. And this type of emergency politics conducted by international organizations also challenges the arguably pro-democratic nature of international law. Particularly, it challenges the claim of global constitutionalists that international law is currently undergoing processes of constitutionalization. And finally, the third problem to consider is whether international human rights law provides states with clear and effective norms for adapting their laws to states of emergency? The answer to this question is likewise highly complex. On one hand, international human rights law seems to have largely accepted the legal adaptation model, in the sense that it appears to be dominated by a legal or rule of law approach to governing emergencies, and rejects the alternative theory offered by Schmidt and others concerning the extra-legal nature of emergencies. The international treaties stipulate conditions for derogating from human rights in times of public emergency, with the expectation that derogation be terminated once no longer necessary. They permit derogation only to the extent that is strictly required by the situation, and only upon officially proclaiming the emergency and informing the treaty depository. So this is a highly sort of legalized approach to emergencies. They provide a framework for adapting to the state of emergency and proposing certain restrictions on executive power during this time. However, on the other hand, international human rights law also gives much respect to the principle of state sovereignty, thus giving states much leeway when it comes to governing emergencies. The state's right to self-defense and its obligation to secure and protect its citizens are accordingly recognized as grounds for emergency rule and derogation of human rights. The international covenants permit the contracting parties to take measures derogating from their obligations under the treaty in times of public emergency threatening the life of the nation. While a few of the rights guaranteed under these treaties are inalienable, even in times of emergency, most rights are subject to the derogation regime. And the derogation regime invokes two main legal questions. First, does the situation constitute a public emergency, which truly threatens the life of the nation? And second, are the measures taken by the contracting state proportional? I.e., are they strictly required by the exigencies of the situation? The problem is that the jurisdiction on these questions is quite inconsistent and lacking. On the first question, the concept of emergency is not defined clearly under international law, nor are concepts such as public order and national security, which are to be balanced with individual rights under the derogation regime. Consequently, international human rights law is also vague on the precise conditions that constitute a public emergency and justify derogation. The human rights treaty bodies have often abdicated responsibility for making this determination and seldom overturn the assertion of a state of emergency by a government. The European Court of Human Rights, for example, has endorsed a wide margin of appreciation doctrine, which entitles each European society to certain latitude in balancing individual rights with national interests. So instead of focusing on the first question, whether this is indeed a public emergency, the courts tend to focus on the second question, namely the proportionality of the emergency measures taken by the derogating state. However, in assessing this question, the human rights treaty bodies likewise tend to defer to the judgment of governments, though there are, of course, exceptions. The European Court of Human Rights, for example, has generally endorsed a wide margin of appreciation, not just on the existence of the emergency, but also on the proportionality of measures. In the context of counterterrorism, for example, the court has accepted far-reaching, extraordinary powers of arrest and detention, void of judicial review, ruling that they were within the margin of appreciation. And as a result, the criteria for legally determining the proportionality of measures likewise remains quite flexible. Finally, even assuming that international human rights law does have a pro-democratic agenda and does provide states with norms for preserving democracy amid emergencies, this does not mean that such norms are necessarily enforceable. When nation states refuse to comply with the norms stipulated in the treaties, despite attempts to enforce these norms through the national courts, then NGOs or individuals may attempt to compel compliance with the treaty through an international court or tribunal. But to do so, the judgment of these tribunals must be binding, and these tribunals must be authorized to enforce these judgments, when in practice, not all treaties are enforceable through a judicial supervisory body. So in conclusion, we argue that international law suffers from significant limitations when it comes to maintaining the core principles of liberal democracy amid emergencies, while international human rights law in particular attempts to stipulate norms that would assist in this task. It also grants individual nation states wide discretion in interpreting norms and in applying them to concrete cases. International law thus seems to reproduce hazardous tendencies that domestic legal regimes also exhibit during emergencies. It similarly leaves much leeway for executive discretion. It struggles to define clearly the precise conditions for declaring an emergency, as well as the exact circumstances that require the termination of exceptional measures. This is something that I forgot to mention earlier. It's also always unclear when an emergency ends, not just what constitutes a public emergency, but also what constitutes the end of an emergency. And COVID-19, of course, is a very good example of this because coming out of the pandemic was very gradual, and you can always sort of argue that the emergency still exists. And this enables the institutionalization of exceptional emergency powers that may be prolonged due to the limitation, the inability to say exactly when the state should cease to use these exceptional measures. We conclude the article by trying to sort of outline the things that international human rights law can do to overcome these challenges, but I must say that both Gadi and I thought this was sort of the less developed part of the article, because, to be honest, it basically says, okay, so these are the problems. If you want to fix them, so you need clearer standards for determining an emergency, clearer standards for determining when an emergency ends, clearer terms for assessing proportionality. International organizations should lead by example rather than sort of reproducing the tendencies that national regimes have during emergencies. And we thought that we might sort of try to think more about how to deal with these problems, perhaps in another project, which sadly we did not get the chance to work on together. But I will try maybe with your help to think of these issues for future reference and future research. Thank you.
Thank you very much. Okay, thank you very much for this fascinating talk, and also for bringing us back to the memory of Gadi. I think I may have heard of an early version of this.
Yes.
At a certain point in our
right. I forgot to mention that.
Yeah, and I think that actually, I mean, I didn't read the paper, but the way that you presented it, it sounded like you made a lot of progress since then. In the way that, if I remember correctly, and you need to, correct me if I'm wrong. I thought that if my memory is correct, in the earlier version, you seem to be a little bit more optimistic about the possibility of human rights solving these problems.
Yeah.
And in this late version, it sounds like optimism is very, very minimal, or let's say, modest. So I think that sounds right. What I was still curious about is the methodological move that you begin with when you say that you want to kind of advance a transnational theory of law as the baseline rather than the domestic or sovereign baseline. And then you move to international bodies, which actually still work with the premise of a strong kind of sovereignty basis. The basic unit that acts in the international bodies that you describe is still the national unit. And so it seems like there is an intermediate level, maybe, of transnational actors that are not international organizations, human rights treaties, or the UN system, but rather maybe on regional levels, maybe on public-private collaborations that may also have something to say about Emergencies. And my question is whether you kind of looked at that, because it seems to be suggested by the methodological move that you began with. And maybe, and if not, maybe this is also, a direction for future research as well.
Thanks. Yeah, I think you're very right. I mean, first, you're very correct that I think we were a little more optimistic at a certain point. This optimism, it does seep into the article a little when we describe actually some steps that were taken by international bodies during COVID-19. When we saw that there was it did seem that some of these organizations sort of upped their game a little and provided states with tried at least to provide states with a lot of guidance. There was a lot of sort of kind of quasi-legal activity, of course, not binding guidance, but a lot of sort of legal or quasi-legal activity during this time. But I think it's true that after we sort of tried to do this, to offer this sort of methodical analysis, we kind of finished it and said, oh, well, I mean, so there's some sort of potential here, but this potential is substantially limited. I mean, each one of the problems ended up being a true problem. Another thing, by the way, there were two very, very productive sessions here at the Minerva Center that I forgot to mention. One is the session that you mentioned in sort of a similar form to this. And a second a forum was the Young Researchers Forum in the Minerva Center, which was also extremely helpful. If I remember correctly, one of the main things also that these two sessions did was help us sort of narrow the article down, because at first we thought that maybe we would also do empirical research sort of, and when we said, let's go and talk to decision makers from various states and try to see how international law influences them. And there were like lots of other bits and pieces in the paper that people told us, I think for very good reason, to leave for a different research. Your second comment, I really agree. I have to say that I was going over the article again before this lecture, and I started asking myself whether the article doesn't also suffer slightly from methodological nationalism. Because really, I mean, it's true that we talk about sort of global governance of emergencies, but we are also quite focused on nation states and their intersection with international law. So maybe, I mean, it would have been sort of better to also look at the possibility of, I don't know, sort of certain collaborations between states and or maybe sort of the go to the public-private divide, like you said, so that we don't just look at national organizations versus sort of international organizations. So I think that's a very good comment, and I think that maybe for future research, it could be maybe interesting to try to compare such organizations with sort of more classic international organizations or treaty bodies, but I'll have to think about it more, because I kind of just realized myself the methodological limitation that we ourselves have.
I think that
Can you present yourself?
yes. Stern Silvia, Dr. Stern Silvia, Hebrew University of Jerusalem, postdoctoral fellow, economics, and I wrote a monograph in economics of transition, Russia on the move, railroads and the exodus from compulsory collectivism, 1861 to 1914. I listened to your lecture with excitement and think that you could use two authors, unless you already are familiar with those. And this is Douglas North, 1990, and Ronald Coase, 1937. I identify in your lecture 3 levels where the rules will adapt to emergencies at different paces. One is the individual level, individual human rights claim. The second is the sovereign state. And the third is the supranational, anti-international law, humanitarian law, and so on. And now, according to Douglas North, the general rules, which is the common denominator of international law, performs will change very slowly and very costly. They are very difficult.
In the international move.
Yes, because this is based on a common denominator of general norms. Those will move very slowly. The sovereign states, I assume, will move a bit faster because there is a geopolitical agenda for each state and it has to adapt. And the individual rights can be claimed in democracies. On the individual basis, the laws are more flexible. This is a question of relative scarcities and so on, more flexible on the margin. Now, applying Ronald Coase, this was Douglas North 1990. Applying Ronald Coase, there is an additional problem with the international rules, humanitarian law. That is, there is a point where the accumulation of tasks actually may produce also the rise in transaction costs and uncertainty that are usually internalized in organizations. This is the Coasean theory of the firm. That the more tasks are accumulated in the megastructure, the higher is the risk of mistakes. And after a certain point, when the economization of costs of acting in accordance to the rule turns into accumulation of costs. So this is maybe it is also fruitful to engage in econometrics in those different phases of adaptation, and this way make the international legal system more responsive to the claims of sovereign states and also to the claims of individual claimants in those states. Because otherwise those discrepancies in the elasticity of adaptation to reforms, the marginal adaptation to states of emergency will be very slow in international humanitarian law, unless this is some kind of a maybe general collapse, as Boyer and Orlan 1993 called it. That is where all vested interests in former rule systems simply collapse, and there is an emergency urge to apply a novel strategy or a synthesis, synergy of novel strategies, and then maybe individual states would make an input which is actually disquieting or destabilizing all forces, an adaptation which is efficient in a very, very short time. You could also look at Boyer and Orlan 1993 in Ulrich Witt 1993, How the Conventions Evolve. Very fruitful article. This is a mathematical theory of institutions, and also it gives various types of adaptations necessary in the times of emergency. Thank you.
Wow. Okay, that was fascinating. I've never thought of it from this perspective, an economic perspective, certainly not a mathematical one. So please keep in mind that this is sort of my undeveloped side. I mean, I really have no knowledge of economics. I don't even come from the field of international law, to be honest, but from the field of criminal law. This was an article that Gadi and I wrote that actually it was we both, I think, stepped a little out of our comfort zone here. But that's very, very interesting. But I'm wondering, is it another cause for pessimism, actually? Because at least North's theory, the way that you presented it, I don't know it, and I'll definitely look into it. It makes it seem like this idea that it could, come sort of top down from international law is even less viable. So, I mean, if there's any chance that it's the exact opposite, it will come from the ground, maybe from individuals who influence states, who influence international law. And I think it's very, when did you say that the North published?
1937.
1937. Okay, so this was a long, okay. So this is the firm.
Yes.
So this is very, yeah.
So for followers, I think that there is a scope to consider that our belief in international law as the final arbiter or some kind of a monitoring body, that this over-belief or excess belief might be misguided, and the sovereign states must also bottom-up monitor themselves through courts, that is independent courts of justice, that also monitor actually bottom-up the, let me say, the obstacles to change and vested interests in international rule systems, and also, of course, to make the whole system sufficiently pluralist, investing in individual states that is sovereignties, monitoring powers, and monitoring negotiation power in such manner that the accumulation of tasks within the megastructure will be checked bottom up, and then it will become more flexible without running into excess costs of centralization.
Thanks. That's very, very interesting and helpful. I think I'll look into it. I think it's very interesting also to think, since it's been a very long time since this book was published and international law was less developed, has this, changed? Is the situation still the same, or is there more sort of a kind of a vibrant and flexible legal activity on the international level, almost, 90 years after this? Yeah. So it's very, very interesting. And thank you.
Also, I think that organizations, that is constellations and treaties among independent sovereign states would provide some kind of a corporate additional level, which is indispensable. On one hand, to check the individual states, but also to check the megastructure, whereas it is not superfluous at all. It is only I believe, excuse me, I don't want, I don't want, that is, it is indispensable to create balances among those levels and create a pluralist organization forum at all levels, actually, to prevent the accumulation of tasks within structures that may run into diminishing returns to organization. This is the Coasian Creed. And be as democratic as possible, bottom up, to be elastic, to change scarcity relations, change scarcity relations in information intake. Also the transportation, the thought transportation system, the internet, and so on and so forth. Those are structures that should be well developed in all states to, through communication, intensify velocity of communication, monitor actually rigidities and vested interests.
Anybody from the Zoom who wants to ask, please let us know. Participants have some. Limor.
Thank you for the invitation. In a way, I have like a preliminary or your baseline, or you're starting with the assumption that international law, I think the first sentence is, and for global norms that assist nation state in preserving democracy in emergencies. And so it goes to the assumption that international law can take such a role of in a way, looking at democracies as something that is naturally good. And I think this is come up because international law is based on states, and most states are not democratic. And I think I go back to Rawls and the law of people, and he is assuming that you cannot assume democracy to be, or liberal democracy, or to be something that is part of the law of people. And I think international law acts like that. So I think maybe a possibility to say it can assist states in preserving their current governance. Or I think I have a problem with looking at the international law as something that will aim to preserve democracy as such, and I would reframe it as something else. So it's fundamental. I know that this is your assumption, but somehow.
No, actually, I disagree. I don't think it's an assumption. I think that's the question that we set out to explore. And I think the first problem exactly goes to what you just said. You can't even assume that international law has a pro-democratic agenda. Exactly. And it's for many of the reasons that you said, that many countries in the world are not democratic. There's still players in the field of international law. Generally speaking, international law is considered to be sort of neutral or agnostic on or pluralistic on this question. So I completely agree with you. But you are right that we make the assumption that democracy is that we think that democracy is the preferred regime.
And that's
our agenda. We have a pro-democratic agenda writing this article. That's absolutely
okay.
correct.
But then you look into international law to see how it assists you with your agenda.
Yes, but or to see if it can assist.
Right,
yes.
But then maybe because we need all the states to agree on that to some, not all, but some in a way, we look at the international community as the players, right?
Yeah.
So so in a way, I think that other framing could be possible in order maybe so usually you're saying that the aims of international is stability, the first, or not the aims.
Yeah.
So maybe if you're framing it as stability, or how do we, something like that, what is the risk in emergencies that disrupt something that states could relate to? For example, but that will be I think just.
Yeah. No, I think you're right. I think so. This is a slightly different article, but very similar. So maybe if that was the question that we set out to explore, then maybe we wouldn't, waste our breath on the first problem and whether or not international law is democratic but it's true that a lot of the analysis can also be applied to the question of, helping, a state preserve its regime type, regardless of which regime type it is. But also international human rights law, while it doesn't have maybe an explicit pro-democratic agenda, it does have an explicit pro-human rights or some civil rights agenda, some of which are central to democracy. And so I think that, some of the rulings on the derogation regime and the state of emergency sort of maybe assume that the idea is to go back to being a democracy, and that is actually that the reason for allowing this temporary derogation from human rights is to preserve democracy. Otherwise, and again, I don't think that this is the general agenda of international law. I think that some treaty bodies, especially the European Court of Human Rights, can be said to have somewhat of a problem.
Sunny.
I have two questions about your assumptions about the relationship between international and human and democracy. First of all, the key actors of international law are countries, not persons. And you have idea of what decides is sovereign countries. So theoretically, at least, a country like Monte Carlo and China are equal players. So it's run completely counter the idea of one person, one vote. So I think that the structure of international law essentially is not democratic in that sense, if you take seriously the idea of democracy.
Very good point.
And my other point is that you ignore, it seems to me, I haven't read the paper, it seems to ignore completely the history of international law grounded in colonialism and, third world, which is his approaches to international law, which sees international law as a tool for, changing colonialism in other systems. So I don't...
Replacing colonialism, you mean? Or promoting?
Well, replacing or
no, I mean, advancing colonialism.
What?
So promoting colonialism or
replacing replacing open colonialism, replacing open colonialism with okay, so
with sort of a alternative but equally sort of maybe like economic oppressive ways of
the system. The structure. It's extreme. If you look at the history of international law, it grew out by the division from the division of the world between the colonial powers and so on. So, why do you assume in both? It's the same question. Why do you assume that international law even wants to promote democracy?
Again, I don't think I assume it. I think that's the question that the article sets out.
Yeah, but in a way, I heard that it's more than What?
No, it's true. We didn't look into the history so much of international law. I mean, or I would say rather that we looked into more of the more modern history of international law, specifically ever since World War II. Because we look at the main treaties that supposedly promote human rights. I think that the colonialist or the historical argument is a valid one. I mean, of course, the history of international law does affect its general agenda, but I also think that it's affected by other forces, not just colonialism, from what I understand at least, such as World War II, the refugee crisis. There are many events, I think, that shaped international law, and I'm not familiar with writing on, sort of the historical or colonialist roots of international law, but I assume that what you just said, I mean, this idea that international law was developed as almost a tool of colonialism. I assume that it's a controversial statement. I mean, that there is much.
Of course, no, but my argument is that your assumption is also controversial.
No, of course it's controversial, and again, I'm not sure that it's an assumption. But what I wanted to say, I think the first point is very strong. What you said about this idea that, I mean, democracy, of course, is one vote per person, and it comes from this idea of equality between people. And here, the most that we can maybe hope for is equality between states. But what kind of equality is this if one state has 2 million people living in it, and the other has 200 million people living in it? I think that's a very, very good point. Of course, you can say that the states themselves, that their decision making could be influenced by democracy, and then this decision making also influences international law. But I think that's a bit of a reach, especially since many states themselves are not democratic. So I actually think that's a very strong argument that we missed. So thank you.
Thanks, Rottem. When you started talking about what is democracy in international law and all that, there is also a question of how do you refer to international law, because it's composed of so many different aspects and so many different bodies, and to focus necessarily on the General Assembly and the UN, this is just one mechanism of how everything works. And, you have bilateral treaties, you have multilateral treaties, regional treaties, and it is important to have a better definition of how do you refer to international law before you analyze what it promotes and doesn't promote. Now, with regard to international human rights law, it is quite complicated to address it either this or another way. Just take the two main treaties, the ICCPR and the ICECR, civil and political rights, and they were established in the 60s. And when they were established, it was like democracies preferred the ICCPR, and Russia and communism, USSR, actually preferred the ICECR. And later on, it was both of them got into all of them, but it was clear that USSR didn't want to go to ICCPR because of its human rights, civil rights, and everything related to democracy. And that's actually the one that also has derogations. This is the important ones, derogations.
Yes.
The other ones don't really have their own derogations. And at the same time, you have within international law several mechanisms of reviews that goes top down, whatever, in different ways. For example, derogations in accordance to ICCPR are reviewed by the Human Rights Committee, right? But decisions made by the Security Council following September 11, as you mentioned, for example, for designation of terrorist organizations or individuals, were overruled by the European Court of Human Rights, saying that you have to have some kind of internal mechanism for each state or for the EU in order to do such a designations. And even now, we're about to see the ICJ, right? They say on Friday the ICJ is going to release the.
Oh, really?
Yeah.
I don't know.
The current news. It's probably going to release this Friday. This Friday. And regardless of what the ICJ is going to decide, regardless to what Israel is going to do, if it's going to comply or not, the important aspect is how other states will react to that. So you have different types of reviews and mechanisms. Even the judicial system is not necessarily making the call, but rather how other states will react to what Israel will do, either adhere to that or disagree with the provisional measures that will be decided upon Israel. And with regard to the comparison, I think also Itamar said that last week in the context of Limor presentation, that there is the presumption that each state has one vote, like US is, I think you said Micronesia or something like that last week. Well, this is pretty much the same as regular state, person versus person. I mean, you have rich persons, you have poor persons. They are not really equal before the law, even though each person has one vote and each person is equal before the law, but this is on paper and you have practical just as well, which is a little bit different.
Thanks. So I agree with everything you say, but I think also that these sort of limitations kind of characterize almost any type of entity that we would try to look at as democratic. I mean, even states themselves, right? We know that there are different types of democracy, and we know that there are, certain aspects in the state that are carried out more democratically and less, and there are decisions in the state that are made on through a democratic process, and decisions that aren't, and there are different types of democratic processes that not all of them are necessarily one vote per one person. And of course, in national politics too, just like you mentioned, there's also big gaps between people, some richer and more influential, some less influential. So I'm not sure that all these things prevent us from trying to think of international law as a whole. Of course, this has many limitations because it's very hard to take any body of law, and this I think is also valid criticism. It's very hard to take any body of law and to try to say whether it's generally this or generally that, because there are many, as you say, nuances and complexities. Maybe a better definition of international law would have been better. So in the beginning of the article, when we say, okay, so this is our definition of democracy, and then it's a little easier from there to go forward and look whether these aspects are promoted by international law or not. It might have been better, I agree, to define international law, or the type of bodies of decisions that we're looking into. We do say that we focus on international human rights law, but perhaps even that is too wide a term. I don't know. Even though we do try to sort of reference these nuances a bit, saying, okay, so this does have a judicial body that you have to comply with, and this doesn't, and this. But of course, it's very hard to write such an article that presents such a sort of general argument or general question, and then also go into all of the complexities. So I agree.
Yeah. We have Robert on Zoom.
Oh, Robert, he's in. Okay. Hi.
I'm happy to see you guys, and Rottem, it's very interesting. And just following previous comments, my question was as to your third recommendation, as to the issue of leading by example, because I couldn't see the correlation between this issue and the outcome that you're seeking. And if at all, I was thinking maybe also like following examples that Ido mentioned, and taking more example from the European Court, like for example, some help it gave in the Poland case. Wouldn't bringing more powers to tribunals be more effective than other methods to actually if we wish international law to be more to have some power to control deviation or push towards democracy in other countries. So maybe tribunals may be a more practical solution.
Wait, I'm not sure I understand. Are you saying that actually the fact, I mean, the question of leading by example might sort of have actually reverse results than the one that we implicated? Because if international organizations
because these organizations suffer from the same problems previously mentioned, I think that wishing for this is going to be a very long way, a longer way to take, and again, the only way just to have some kind of improvement will go through some mechanism such as a tribunal that can actually enforce the same notions, the same ideas that international law can contribute with to preserve or promote democracy. Okay, so my idea is just, if at all, tribunals may have some kind of impact, positive impact, maybe more than international organizations.
And which tribunals? I'm not sure that I understand. Which tribunals exactly would?
That's a good question. Maybe moving into we see the example that where there is a tribunal which deals with human rights it's a regional one, right? It does help in some cases, not even directly or indirectly, to preserve some human rights that can stop countries from deteriorating, at least towards something which is not democracy. Okay.
Yeah.
And maybe if you can copy that, move towards that in other places, that would have a better positive impact, or something which is actually something which can contribute to the outcome.
Yeah.
Otherwise, I fully agree that the issues of better drafting and understanding proportionality, that the substance that can help. Okay, once the substance is better, then it could guide countries better if they want to. But in the case they don't want to, maybe a tribunal can be a solution, or a mechanism, finding more mechanisms that can push into that's closer to the outcome, I think, than or the leading by example.
I think that's a very interesting point. And I think also that one thing that I kind of hear from several comments is that maybe that we need to think about sort of international organizations or tribunals in maybe in a less sort of rigid way, not just think of, like the treaty bodies and the state, but try to think of sort of maybe hybrid, something that's more between the national level and the international level, or maybe even between the private and public sector. Try to think of like different types of tribunals that could help with this. And also, I think maybe in a way this could also go to what, sorry, I forgot your name. Silvia said about this problem that international law actually moves slower than national law. So maybe, this could also be a way to help deal with this fact by I don't know, somehow creating a better cooperation between the national and international level. I'm not sure, because I'm not really sure how this would look, like these kind of tribunals, but I think it's something to think about and maybe read about, because it seems to come sort of from various directions. Thank you.
I want to ask. Thank you for your fascinating presentation. I found very interesting insights. I had issues with this categorization of 3 models of emergency, which I think are familiar with the different categories. But I want to go to the main point on the effect of international law on emergencies. And I want to offer you a distinction between global emergencies and local or regional emergencies. And I think the role of international law might be different in these two kinds of emergencies. You know, we had very rare global emergencies. And Corona or COVID-19 was one of them. I think the main predecessors were World War I and World War II, where they transformed international law very much. It was not that international law had an effect on the emergency had an effect on the creation of the League of Nations, the creation of the UN. Basically, the human rights treaties are an offspring of the Second World War. And what was really fascinating, so I think that it's a different category from how international law interferes with emergencies that are concerning local or regional, like our emergency at the moment. But what is really interesting in this context, if this distinction makes sense, is that the COVID-19, which was the first real global crisis after probably World War II, there was no role of international law. The role of international, it didn't affect international law. And international law didn't really have any effect on, very little effect, I think.
Yeah.
Or, you know, maybe the Health World Organization had a lot of information provided and kind of advices, but there was no real intervention of international law governing the crisis. So what made COVID-19 different from various global crises is an interesting question, which I think might be a continuation of your article.
By the way, when you offer this distinction between global and local regional emergencies, do you think that the distinction comes mainly in the form of legitimacy, that it's considered less legitimate for international law to intervene in national or regional emergencies, or not in this sense?
From a positive perspective, when everybody is in crisis, all the players in an international, all the states, you know, relates to them directly. So there might be a very different dynamics of how to manage the crisis. And in a crisis that you know, happens between Russia and Ukraine, and for us it's really not. The consequences are minor, and then our role of the international law role might be a different role, maybe more kind of strategic players or lobbies or interests of big players in the political arena, which have different aims and goals. While when you have a global crisis, a world war or a pandemic, then everybody has the same interest in overcoming it.
Right, and I think that in terms of what makes COVID-19 different, and I think this is, you know, it has very much to do with this. I mean, first of all, it really, truly was a global crisis in a sense, all over the world. And second, I think it's one of those global crises that perhaps also cause a little less objections to this idea of global governance, or because it's not a political as such. It's not one of these crises. There's no enemy. There's no war between countries, right? It's not like if I get COVID under control in my country, it somehow takes something away from another country. On the contrary, it provides a positive example and it helps, and it means that the pandemic might spread less. So I think this is one of the maybe a very kind of rare type of crisis where there truly is a reason to cooperate. And
so there is
we can also
but
there
was no real international. I mean, there was no real international law, and each country dealt with it in very different ways,
right?
And that was
right, and hence why we thought about the article, but also I think. Actually, it's a very good question because there are other cases where global cooperation or global norms would be very helpful, right? So think of climate change, for instance, where there's no enemy, supposedly at least, and yet. So I would think that these types of crises where there's no enemy, there's no room for states being pitted against each other, but there's more a reason for global cooperation. I would think that these would be the type of crises that would generate more sort of international norms and rulings.
Right?
Well, they did a little bit, and we showed this in the article. There is some, they did a little bit, but on the other hand, they also, I think that the COVID-19 also showed the weakness, for instance, of the derogation regime. Because, for instance, a notification regime, you have to come and notify, right, the treaty body that you're now derogating, essentially collapsed during the COVID-19 pandemic. States just didn't do it. They just took all kinds of special emergency powers and didn't bother notifying.
What did they do? What was the little that you found?
The derogation regime. What we found was that a lot of these bodies, like the what's it called? The Inter-American Court and the European Court and the UN Human Rights Committee and several bodies issued lots of guidance for states concerning the derogation of human rights in times of COVID, try to offer all kinds of rules in terms of proportionality when derogation is justified, proportionality when it could be seized. I can't say that we know that there was a high level of compliance necessarily with these rulings, but there was sort of for I think a year or two some kind of heightened activity and trying to provide guidance to these things. So that was one thing. I don't know if very optimistic, but that was one thing that we did find during COVID.
More than 100 countries announced a state of emergency.
Yes.
State.
And I think less than 5 notified, or something like that. In the article there.
Just follow up on previous points. So as you were speaking, I was remembering that during the COVID period, we also had a talk with Professor Benvenisti. And at that time, he was speaking about how states have been during this. It was still at the time of the crisis, are proving to be a very bad platform for cooperation against the spread of the virus. And he was kind of advancing the idea that large tech companies would be the solution, including Meta, Google, because of their capacities to survey many users in terms of patterns of
Okay.
We're very much optimistic.
So
he was right, but it was not the tech, but the medical. Without
well, I mean, that leads us also to questions of patents. Who got it, who didn't get it, and what duration. So, I mean, I think these are not so simple to say, okay, he was right or he was not right. This is a more complex thing here. But what I think is the reason why I bring this up in this context, that I think that it can provide you with some. I mean, I don't know how much you plan to pursue this, but if you do plan to pursue this, it can provide you with some kind of reaction or response to the kind of criticisms that have developed around this table, in the sense that you can say, okay, so what's the alternative?
Yeah.
And if the alternative is large tech companies,
Right.
which may be the alternative among several commentators, and not only Benvenisti, in a larger kind of literature that is developing around transnational governance by firms, then maybe still the human rights system or the international law system in comparison has more checks and balances, is more liberal, is more democratic, whatever you want to talk about.
Yes.
Yeah, whatever you want to say about it. So it's not, it doesn't meet a kind of test that requires democracy of one person, one vote.
Right.
It doesn't meet other liberal democratic tests that we may have in the domestic level. But in terms of the fact that sovereign equality is presumed, as Ido said, it's still better than a system that is simply based on economic incentives and nothing else.
Yeah.
So,
right.
Yeah. Okay.
Yeah, I agree completely. Nothing to
I don't know if this is this is a hypothesis, but maybe one that can be useful in the future if you do end up looking at this again.
Yeah. No, the question of the alternative is definitely because someone will eventually sort of fill these shoes or fill this role, and it would be better probably to be in the public sphere enough.
I think Benveniste thought that Facebook in particular at that time has a very liberal board, and so they're fit for the task.
Okay.
Maybe
I agree. That's probably.
maybe international law should actually take corporations.
That's what he said.
Should take corporations as a project to regulate.
Yeah.
Well, human rights in corporation, not in states. Human rights, democracy in corporations.
We do have business and human rights. We're trying to promote human rights into business right now in international law. There's an entire project in the Human Rights Council and in Geneva of human rights and business. So before we use their business to regulate democracy, we need to make sure that they actually use human rights within their own operations.
Good luck.
I mean,
Thank you very much, Rottem.
Thank you. It was good to be here.
Thank you.